Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about driving under revocation, or DUR. But before we get to that, don't forget to click like on this video if you're enjoying it, and click subscribe on the channel with a little bell next to it to be notified of future videos. What is driving under revocation, or DUR? Let's start on this one with the statute. So this is 42-138. It's always charged as a it's always charged as a state charge, not a municipal one. There are other municipal charges like driving without a license or driving without a proper endorsement, something like that. This is driving under restraint, and it's pretty specific. Used to be that they didn't have to prove knowledge that your license was suspended, but now, as you can see right in this first section, with knowledge that the person's license or privilege to drive, that's new as of about 2-3 years ago. And if they can prove your license was suspended, that you knew your license was suspended by either notification with your signature on it or a judge telling you something that they can present to a jury to show that you knew your license was suspended, then the penalties get pretty severe. Let's take a look at this. So it's classified as an unclassified misdemeanor, which just means that you can get up to 6 months in jail and a fine of not more than $500 for a first offense. So on a second conviction, the penalty doesn't go up, but the driver's licensing does. You won't be able to get a license for 3 years if the two DUR convictions are within 5 years of each other. That's a 3-year license suspension. Now, for alcohol driving offenses, things are a lot more severe. There is a mandatory minimum 30 days in jail, which means if you get caught driving when you shouldn't be, you know you shouldn't be, then the penalty for that, the judge has to give you at least 30 days in jail, but look, up to a year. So a second offense, the mandatory minimum period of time that the judge has to sentence you to jail is 90 days, and you can get up to 2 years in jail. Plus, it cannot be suspended. Now, notice here there's an emergency driving exception, meaning that if you were driving somebody to the hospital for medical treatment, that sort of thing, you might not have to go to jail, but you're still going to get that license suspension. And any driving under revocation is going to be a habitual traffic offender strike, which is going to mean that if you get enough of them, so you get one, you get a second one, a third one within a certain amount of time, which I will talk about in the habitual traffic offender video. If you're interested to see that sooner than later, put it in the comments below. But a habitual traffic offender will get your license suspended for 5 years, 5-year license suspension. So let's take a look at this. So driving under revocation is driving after your licenses to drive have been suspended, or they're under restraint. Could be here in Colorado or in any other state. And what happens is you get 12 points. So just the points alone will suspend your license for an additional year. And under the Department of Revenue regulations, if you're driving when you shouldn't be, there is no early reinstatement or probationary license eligible. So that's pretty severe. So that is the question and answer for today. If I didn't cover something in this video that you'd like explained a little bit better, put them in the comments below. If you want your own question answered in a future video, or you can tag me on Twitter or email me. And as always, you have a right to remain silent. If a police officer asks you questions about what you've done, what you have, what you know, where you've been, anything, you always have a right to say, I don't want to talk to you. And if they persist, you have a right to say, I want a lawyer.